Good morning, everyone. Welcome to our webinar today. The topic, a very important one, the only way is ethics. What can GCs learn from the post office scandal? I'm Philippa Dempster. I'm the senior partner here at Freeths, and I'm a member of the litigation team. And I'm delighted to say I'm joined by James Hartley, who led the post office case on behalf of the 555 postmasters, and also with Jonathan Canning, who is our principal of the Chief Legal Officer Service. Jonathan's a GC and very much has worked at the sharp end in businesses and still does. And so he's going to help us to share some actual practical tips on some of these important topics today. So we're going to record the webinar, and if you'd like access to it afterwards for your teams, or if you've got any further questions, then be delighted to talk to you about that and provide access. We also would love to have this session as being an interactive session. Indeed, part of it later on is going to be talking to Jonathan and James. And so please, if you'd like to ask questions, use the Q&A chat box. Well, sorry, the Q&A box rather than the chat box, and we'll pick those up as we're going through. And if there's any other aspects that you would like us to answer afterwards, by all means, get in touch with any of us. So, on to the agenda. Today, we're first of all going to look at the post office case and what went wrong, and James is going to share his insights, having been very much at the front of that case for many years. I'm then going to cover the SRA duties and guidance and provide a little bit more of the background to our obligations. And then we're going to be talking with Jonathan and James about learnings and practical tips. So without further ado, over to you, James.
Thanks, Philippa. Really pleased to be able to talk to you about what we saw unfolding in this horrendous scandal and some of the professional ethics issues that we think arise out of it. First and foremost, if I could mention the 555 postmasters and other postmasters affected by this scandal, enormous human impact. And the good news is that the various compensation schemes that are underway are starting to ensure that compensation is flowing to the postmasters. It's a lot slower than we would all want because the issues are highly complex on quantum, but it is happening, and that is really good to see because the human impact has been absolutely horrific, which I'll mention a little bit more in a few moments. What I'll do is, during the course of the next few minutes, give some views on some of the issues from an ethical perspective and also from a litigation perspective. In a highly complex situation that unfolded over many years. These are just views. Happy to be challenged on any of them. What will be really interesting is to see what comes out of the public inquiry output and various other regulatory investigations which are underway, again, which I'll mention in a moment. If I can first give a little bit of context, which I think will help to frame some of the points that we'll talk about. When I was in the process of preparing this, it suddenly dawned on me that it's 10 years this month since I actually made the first phone call to Alan Bates, as per episode 3 of the ITV drama, for those of you who've seen it. And that was a call to Alan as a consequence of me listening to the Radio 4 Today programme on the way into work here in Leeds one morning, which did prompt me to think that it didn't sound quite right, what Post Office were doing to the postmasters pursuant to the contract. Alan and I then met at a hotel in Chester over a coffee, and then Alan is quite cagey in the way he approaches things sometimes, and indeed he was cagey in that conversation, but gave me enough information, or I managed to start to extract the information, which then enabled me to sort of understand what had happened, or begin to understand what had happened. And what Alan explained was that he was representing as a non-lawyer, around 50 postmasters at the time. He had been pushing for 6 or 7 years, but being blocked by Post Office in relation to what had gone wrong with Horizon. And what we were presented with was a situation where we had quite a few postmasters who had convictions. There was a one-sided contract. Limitation had expired on a lot of the cases. And we knew Post Office were highly likely to resist. And furthermore, as Alan explained, we have no money. And by the way, James, we can't lose this. So we were presented with quite a challenge. But it was one that we could not walk away from. I mean, we started to attend a number of the group meetings at village halls with Alan, and the stories we began to hear from postmasters were incredibly harrowing. And the more we heard, the more we realised that something very serious had happened. And it didn't take long before we started to piece together the evidence. And I can remember one of the meetings at Village Hall where we asked a question of 50 or 60 postmasters, you know, who in the room was told by Post Office that they're the only one having the problem with the Horizon system. Sure enough, 15, 20 hands went up. We'd already obtained a number of witness statements from postmasters independently asking them that question. So this all looked very worrying. Alan had also provided me with the second sight report, or one of the second sight reports, which I'll come back to, which did highlight problems with the Horizon system. I then also met with Richard Roll, the Fujitsu IT technician, all of which was then adding up to enough to move it forward and eventually obtain litigation funding from Therium. The nature of the case, of course, as many of you will appreciate, is that the 11,500 Post Office branches used a point of sale system, computer system called Horizon, and what Post Office had been doing since year 2000 was relying on that evidence from the computer to make financial demands of postmasters, ranging from a few £100s up to a few thousand, up to tens of thousands of pounds. And the basis of that was that the computer would say that there was less money in the branch, less cash in the branch than there should have been. Therefore, that was a shortfall. Therefore, postmaster had to pay under this incredibly one-sided contract. Worse still, Post Office not only claimed the money, but they pursued bankruptcy proceedings, criminal proceedings for theft and false accounting. People lost their houses, families were broken up, there was illness, absolutely horrendous. The litigation that we managed to launch with funding was a group litigation order, which we issued in 2016, and that eventually led to 2 High Court judgments produced by His Honour Mr. Justice Fraser. Exceptionally detailed judgments, which followed 2 6-week trials, which were bitterly fought by Post Office. And it was those judgments that thankfully established liability against Post Office, which then led to a significant raft of additional things that have happened since then. And Jordan, if we could move on to the next slide, please, because I think here we see some of the consequences of liability having been established against Post Office. So the unprecedented quashing of approximately 1,000 criminal convictions by statute, public inquiry, and it is anticipated that the output from that public inquiry will be produced this year, although there is no fixed date for that. 4 compensation schemes involving several thousand postmasters. We're acting for several hundred postmasters in those schemes. The SRA conducting over 20 live investigations into solicitors who've acted for Post Office, the Bar Standards Board, regulatory action anticipated, and also the Metropolitan Police, who are pressing forward with an investigation. And the indications are that there will be prosecutions. We can't predict whether that will include lawyers, but there have been suggestions that it will. So very significant consequences have flowed. So how on earth did it all go so terribly wrong at Post Office? Well, I mentioned the inquiry, and there will be significant factual findings by Sir Win Williams. So I'm not in any way preempting what those will be, but we can express some views in any event. The history of the matter obviously presents a very complex factual matrix, and I find it useful to look at it in 2 phases. First phase between the year 2000 when Horizon was installed, and then 2013 when the second site report, or reports as it turned out to be, when they became available to Post Office, and there was debate within Post Office about them. And then the second phase between 2013 and 2020. Lawyers were involved at both stages all the way through, and I'm not suggesting that any of this was straightforward for the lawyers involved, either in-house lawyers or external lawyers. It was a highly complex situation. But I think that as many of us in our professional lives have found, the more complex a situation is, the more there is the need to go back to the fundamentals to actually work the way through it and see the wood for the trees. But obviously it wasn't just lawyers involved in this. Post Office, the decision makers within Post Office obviously also have come under a lot of scrutiny within the public inquiry, which has involved around 100 days of hearings, and evidence has been heard from around 100 witnesses. Moving back to the phases, the first phase, I would describe that in some ways as the destruction phase. That sounds a bit dramatic, but that was the period over which there were all of these prosecutions happening, principally private prosecutions by Post Office. And it is the period over which there was debt recovery, threats made to Post Office, and the livelihoods lost, houses being searched, really, really horrifying things. And that was all in the context of the Postmaster contract, which, as I mentioned earlier, was a very one-sided contract. And I think that was one of the early opportunities for Post Office and those advising Post Office to have put together a fairer contract, not least because the postmasters were very much operating in partnership in many ways with Post Office. They were independently contracted people running their own little businesses, and principles such as good faith, we argued in the group litigation order, should have been built into the contracts, and indeed they were, by means of implied terms following the group litigation. But that phase was when the damage was done over those many years. And within that as well, the approach to prosecutions has come under a great deal of scrutiny, including failures around disclosure of information as part of the prosecution process, and also disclosure issues in relation to subsequent litigation, including the GLO. again, within that period, I think dysfunctional corporate culture is another phrase that comes to my mind, and lack of proper governance. And I suspect there will be an awful lot of discussion about that in the output from the public inquiry. Fear of reprisals was a consequence of that, which we saw time and time again. The postmasters were terrified about even joining the group litigation action. And this all stemmed from an acute sense that within Post Office, the principle was always protect the Post Office name and the Post Office brand at any cost. And I've no doubt at all that impacted lawyers, in-house lawyers and external lawyers acting for Post Office. The default position was, well, what do we do? What do we do to protect the name of Post Office and protect the reputation of the Horizon system and the Post Office as a whole? That was the default position, which put inherent pressure, no doubt, on the lawyers, particularly in relation to their duty to act independently and to uphold the rule of law, which we'll say a little bit more about in a few minutes. The full picture of the way in which the business had been operated was set out in a great deal of detail in the judgments that I mentioned earlier on. The Court of Appeal described Post Office's approach as akin to that of a Victorian factory owner. And certainly what we saw as we were reviewing the hundreds and thousands of documents and board minutes and other Post Office related documents as part of the litigation, we saw a very siloed corporate structure, many layers of management, many departments, left hand not knowing what the right hand was doing. And importantly, lack of clear lines of accountability, both within the commercial side of the business and also as between the managers and directors of the business on the one hand and the lawyers on the other. Dehumanization is another feature of what we saw, what we've seen in the first phase that I mentioned between 2000 and 2013. By that, I mean, we saw numerous instances of whether it was board minutes or notes to the board or internal memos, in which the reference to the numbers involved, so 11,500 branches, hundreds of millions of transactions going through the Horizon system every week. And the discussion was about numbers. It was about issues such as, well, with that many transactions, with that many postmasters, we are bound to have a number of issues. We are bound to have a number of problems in the computer system, but they're only a small proportion of the overall piece. But what nobody seems to have done over the years, as far as we can tell, and we'll see what the inquiry concludes on this, is nobody within Post Office or advising Post Office appears to have taken a step back and said, well, hang on a minute. Even if there is one incorrect prosecution, then that is one too many and it's unacceptable, i.e. thinking about the human impact of what was happening across the business. Denial is another feature that we saw consistently, not just in phase one, but also throughout the whole episode. Denial about the problem, the nature and extent of the problem, but also within the context of the group litigation order. By way of example, a very early stage in the proceedings, we had raised the subject of faults in the system, and we managed to establish that there was a database within Post Office called the known error log. So wasn't rocket science for us to then be asking for details about the known error log, because it might shed some light on known errors in the system. The response we got back in the defence was, well, to the extent that the known error log exists at all, it's not relevant. Which, yeah, that was just one of dozens of examples, and indeed, Judge Fraser, in one of his judgments, referred to Post Office's case in many ways being akin to, or arguments in the case being akin to arguing that the Earth is flat. So the denial was constant denial was a feature throughout. I think delusion, as well as the other phrase I would use, that we saw. So arguing constantly that the Horizon system was robust in the face of evidence that clearly demonstrated that it wasn't. And I think as well, we saw that playing out at board level from the documents we saw. And again, by way of example, I can recall one note to the board of Post Office in which there was a reference to the fact that the number of criminal prosecutions, had increased as following Horizon system being put in place. And that was presented as a positive, because the argument was, well, isn't it great? Now we've got a computer system, we can actually identify and find the postmasters who are stealing money. Therefore, we're prosecuting more. And of course, that was arguably a sort of toxic distortion of the reality. The reality was that the number of prosecutions was going up because there were more problems in the Horizon system. So a whole host of problems in phase one. Phase two, I would describe more as a containment phase. So by 2013, the second site report had identified real issues. Indeed, one of the in-house lawyers at Post Office, who's given evidence at the inquiry, Susan Crichton, did make some attempts to encourage the Post Office board to address those issues head on. And so those of you who've seen some of the inquiry will have seen that at one point she wasn't given access to the boardroom. So that obviously created real issues. The diffusion of responsibility is another feature that we've seen throughout this scandal. Paula Venables and others at senior level within Post Office quite quickly began to shift blame and responsibility on the in-house lawyers. And again, this has come out in the inquiry, where senior decision makers, senior managers at Post Office have been clear to say that actually, when it comes to lines of accountability, prosecutions, that was the role of the in-house lawyers, that was the role of the GC, and then indicating that there was not enough information in front of the board for them to see that there was anything wrong with the way in which those prosecutions were being pursued. I think also, finally, in the second phase, I'd mentioned the symbiosis not being achieved as between the in-house lawyers and the external lawyers for Post Office. There was very much a focus throughout on formulating clever arguments and clever strategies to kill off the threat to Post Office. And I can mention that because that has come out in evidence in the inquiry. But there were numerous opportunities, I think, for in-house lawyers and external lawyers to work together to to demonstrate to the board of Post Office and convince the board that even if there were, inverted commas, clever contractual arguments, that didn't detract from the fact that there'd been massive human impact from mistakes that had been made in previous years, and that the right thing for Post Office to do was to find a way of bringing the whole thing to a close without fighting tooth and nail from 2015-16 onwards through the High Court, and also finding a way of explaining to the board that, quite apart from the need to do the right thing, there were significant reputational and financial risks for Post Office if they continued to defend, and if it didn't go their way, which of course we have found that it didn't. The extent of the defence by Post Office and the fighting, I've mentioned it already, but it really did come to a head when Post Office sought to recuse the judge in the group litigation, and I think it's quite telling that even at that late stage, 2018, 19, 20, when some of the leading KCs in the country were brought in by Post Office to advise on this, they were still fighting, and I think that raises a lot of questions really as to how it was that nobody was able, it seems, to persuade Post Office that actually, no, now is the time to stop this fighting and do the right thing. Key threads running through the sort of 20 years from 2000 onwards, I think one of the main key threads is impaired sense of professional independence, which in my view was evident with certainly the lawyers, in-house lawyers and external lawyers that we were dealing with. That, of course, was coupled with what I mentioned before as being the dysfunctional corporate culture and inadequate corporate governance. Moving on to what might have changed the course of all of this, clearly there were multiple factors at play over many years. But again, I think that if a combination of senior management and lawyers had been able to see the wood for the trees and asked themselves, right, is anything happening across our business which is having a significant impact on humans, on people, namely postmasters? The answer would have been, well, yes, actually, we're prosecuting people, and we're making people bankrupt. And I think that there was numerous opportunities for management and indeed lawyers advising them really to take the view that, right, well, until we've absolutely ruled out the risk of there being one single prosecution, then everything has to stop. Stop the prosecutions, stop the enforcement, and let's get this onto the right track. Finally, for me, just to end on a positive note, if I may, some of you may have seen the Lawyer on Monday. There was a report mentioned called Lawyer Wellbeing, Workplace Experience and Ethics, which was a study that came out of Australia actually in April. And in short, that study finds that a more positive ethical climate strongly correlates with better well-being and lower distress among lawyers. So there we have it, yet another reason for organisations to create ethical environments. Okay, thank you, Philippa.
Thanks, James. And if I'm now move on to this regulatory framework that we have. I think what's really helpful now is from November 2024, there's some fantastic guidance on the SRA website. It's really accessible, very easily readable as well, and has some very useful tips in it. Essentially, as an in-house lawyer, you have the same obligations as a private practice lawyer, but actually working in-house with the same organisation can also sometimes feel like you're in conflict, and you are to a certain extent, because you do have duties to your employer. And those, of course, are going to be to act in their best interest, but also to keep things confidential. But overarching that is still your regulatory obligations, which is around this code of conduct that we all share, both as in-house and private practice lawyers. And a lot of those things you touched on there, James, the upholding the rule of law, making sure there's a proper administration of justice. I think this bit is really important, the upholding of trust and confidence in the profession. And that, seems to permeate across so many different areas when you step back from it. As a lawyer, if somebody is looking at your conduct, do they have confidence in the legal profession, or do they actually think that you're subverting the legal process in some ways? It's a very high standard, as is acting with independence, honesty and integrity. And that line, the idea of acting with independence and actually acting with independence, I think is very tricky when you're working in an organisation, be it a small organisation or a large organisation. Sometimes the smaller the organisation, the harder it is, because you're very much involved with the management teams. So if we can just move then to the next slide, Jordan, please. So I think this is really helpful guidance about what should be reported, or what concerns you should be wanting to escalate within your organisation. And these are areas where turning a blind eye simply isn't good enough. If you do, then you will be severely criticised, and potentially other ramifications will flow from that. And I think it can often be difficult, because raising it can mean, oh, please don't say anything about that, or it's not my fault. I've certainly heard in-house counsel mention this to me in the past, where CEOs have said, oh, I'm not involved in that, so why are you wanting to pursue it? Why do we have to investigate it? Well, these things are really important to be investigated, even if they're not true. When allegations are raised and there is some evidence there, it's important that we just don't put them under a stone and forget about them. So some good examples here: circumstances in which loopholes are exploited with a clear aim or outcome of defeating the intention of the legislation, actual or potential breach of regulatory requirements, a breach of law, a risk that requires the organisation to take action or report to an external body. And on the local authority side, for those of you on today from a local authority, the monitoring officer has a very important role, to make sure that because they're under a statutory duty to formally report any act or actual likely prospective breach of law or code of practice, or on any maladministration. So just moving to the next slide, Jordan, looking at how you go about reporting a concern. So the most appropriate thing to do in the first place is to escalate it, but you don't have to go right to the very top unless it's something that you at board level, as a board, somebody on the board know about. Then clearly at that point you do need to talk to other board members, and to senior management. But if you're at more of a junior level, or if you're involved in something, even as a GC, where you're part of a team giving advice at a lower level, then it's important to escalate it to the people that are in the more senior management position, so that they have an opportunity of looking at it and deciding what to do. It also means that you can then later escalate it further if you need to. But it's this importance of the independence of an in-house counsel really does ring home across all of this. It's that ability, as James was talking about, is to stand back and say, actually, are we doing the right thing? Is that, what should the business be doing? Are we acting with integrity? The ways of actually reporting it, a lot of people look to do it through the whistleblowing policies, as a PID, a protected interest disclosure. But of course, if you're in a small organisation, you might not have a fully fledged whistleblowing policy, and that might not be the most appropriate way of you doing it. So what's always important is to have a think about it in advance, if you haven't already done so, about, if this happened, how am I going to raise an alarm? What is the process? And if you're a junior lawyer on the call today, then again, looking at, well, how should you escalate it within your team, up to GC? So taking no action at all isn't a sensible option, because you will definitely end up being complicit or suppress it. And that isn't something that you would be wanting to do if you're going to fulfill your duties, and also think of your career and any wider ramifications. Always consider further escalation if you can. If you've escalated it to one level and it's not getting through to the next level, ultimately, there is guidance to say that you should be thinking of resigning and actually doing so. Can you, and this is sometimes a question that we get asked, can you then help to change the course, to not necessarily cover things up because you don't want to do that, but get the business to change course and maybe achieve what they want to do a different way? Absolutely you can, as long as you're not breaking any of those obligations, and you can also help the business to take steps to do things differently, as I say, to meet that objective legitimately. The other important part, not just escalating internally, is to look whether there are any obligations to report to any other body. Some of those will be obvious, like the National Crime Agency or FCA, if you're a business that is regulated, but others are probably less so. So if you have a look at the Department of Industry and Trade website, they have a list of what needs to be reported to whom. So if you are in that situation, it's definitely worth having a look. Next slide, please. This just gives you an indication of some really useful resources to where to get help from. I think not feeling alone is really important in this scenario. You, of course, can take some legal advice as well, and also talk to fellow GCs. But ultimately, I've certainly found in private practice, the SRA's professional ethics helpline has been really helpful. And I know for those people feeling stress within an organisation, LawCare does some fantastic work. So a couple of certain personal recommendations, but here's some wider ones. But now I'd like to bring this a little bit more to life and talk to Jonathan in the first place, and then bring James in on the conversation to find out a little bit more about what it's like at the sharp end. Because we have, we know what went wrong in the post office, or we can see the damage that happened at various stages. And also we know, we've just done a whistle-stop tour through some of our regulatory requirements. But how does it feel, Jonathan, as a GC? And I think I know you all and some of your colleagues and friends have been involved in these types of scenarios. How does it feel when you're in that scenario?
Hi, everyone. Thanks, Philippa. I think the first thing to say is ethics permeates through all of our working lives. And we've heard from James about the post office, which is probably one of the largest scandals this country's had for quite some time. The chances of us hitting another one, hopefully, are slim. But what we're talking about really is confronting senior execs or something that could have significant impact if it went unaddressed. And I have to say, it's incredibly lonely. It's incredibly uncomfortable. I've had to do it not often, thankfully. Some of my peers have had to do it. And initially, what we found was you start to question your own judgment for a split second. Did I actually hear that right? Is my investigation correct? Then you start to think, okay, is there a plausible explanation for this that doesn't mean there's a problem? But quickly instinct and conscience kicks in. You suddenly realize I need to do something about it. Some of the questions that are pretty common are, what support will my colleagues give me? Will I become a pariah if I raise this? And then there's the elephant in the room. Will this cost me my job? Or in case it costs my engagement? Slightly more important if it's a job, because the Chief Legal Officer service engagements tend to be shorter anyway. But what has come to the fore, both in my own thinking and those that I've spoken to, are when it comes to could this cost me my livelihood? You suddenly think, well, this is job versus career. Without being flippant, it's easier to find another job. It's very difficult to restart a career. And then there's the people side to it, as James alluded to. What's the value of my own personal integrity? But I think, so with all of that in place, with all of that considered, it's not a pleasant place to be, if I'm honest. And this is where networks, both within the business and similarly minded people outside would become invaluable.
So what strategies have you adopted and do you adopt to try and mitigate this sort of scenario, Jonathan?
Without being cliched, prevention is most definitely better than cure. And the role of any in-house lawyer is, you touched on it in the conduct, professional conduct guidelines, is to act in the best interest of the company, which sometimes will be different from the interests of individual leaders. You've got the independent point and a number of others. From my point of view, I've always approached it on the basis of how do I support a business achieve its goals correctly, compliantly, and ethically. And that starts long before we start to realize there's a problem. Because ethics is about people, it's not necessarily about risk management processes, although they form part of it if you realize there's an issue. It really goes more to culture. So from a GC perspective, building the relationships, proper business relationships with people help. HR, for example, tends to closely align with the legal function at times. But trying to, if the legal team gets a reputation of genuinely trying to help, whether it's sales, operations, whatever the different internal departments are, help promote what they're trying to do, it gives us an insight to be able to steer at an early stage. And that to me is probably the most valuable. That's what I meant by prevention is better than cure. Because we tend to have our fingers in a lot of different pies, provided we are cognizant of our own conduct obligations and things, and read the culture of our own businesses properly, we, for the most part, should be able to try and steer different projects or different attitudes away from major catastrophe. There will always be things that need to be addressed, whether it's a pleasant conversation with a colleague or a less pleasant one. But building that reputation within the company of being someone that's supportive rather than another cliche, the business prevention department, will go a long way to helping. Because when the time comes where we have to stand up and say no, and I really mean no, people take heed more often or more quickly.
And something that James mentioned was the criticism by some people on the board of the in-house lawyer in the post office case. So in those sort of scenarios, the blame has come back to the in-house lawyer for not doing things appropriately. Whether that's right or wrong, we obviously can only speculate. So how important is it to take notes or to write things down in those scenarios? And is that something that you would recommend?
It's always useful. It tends to be a reactive approach. Yes, as lawyers, we should. There's a time and a place for recording things. It can be a useful tool to protect ourselves. It can also be a useful tool to try and influence those around us. CEOs and senior leaders generally don't like receiving a written note highlighting steps that need to be taken, and they usually can read between the lines as well. So yes, it is something that's useful, but I still think the important part is influencing early. It doesn't mean to say that the in-house teams have to have all the knowledge, because we won't. It's actually, before escalating anything serious, it is important to get the facts straight. It's incredibly important. But my recommendation to anybody is perform the role of the in-house team of the GC in a way that influences now, and it'll reap rewards and pay dividends in the long term.
And is it really bad people in organisations, or is it bad culture that causes these issues?
Well, culture drives behaviour, and ethics is centred on behaviour. I don't believe that most people set out to deliberately act unethically. I think most businesses do want to do the right thing. We're seeing that with the increase in ESG and diversity, inclusion, and the like coming to the fore. So I do think most people and most businesses want to do the right thing. Of course, there'll always be some exceptions to that, but from 25 years in-house, I would say that's very much the exception rather than the rule. I think what's more likely is with the pressure of increasing profits or growing or whatever, people are more likely to stray into this inadvertently, which is actually, does it make it easier? Not sure. What it does mean is, and one of the things that I and some of my peers have adopted is when we see that happening, it's about giving the person the ability with a solution to save face. And that usually will cause the activity in question to stop. Now, clearly, there are exceptions to that. James mentioned some of them in the post office where reporting is required. But thankfully, the number of post office catastrophes are small.
A question from our audience today about resigning. It's obviously a drastic action for most people. Would you potentially have a claim for constructive dismissal if you were forced to resign because of a conflict between your professional duties and your actions of the employer?
Depends very much on the factual matrix. I know of at least one instance for myself, and I know where I had to call my wife one lunchtime, say I might be coming home unemployed this afternoon. She was also a solicitor, so she had the same awareness of conduct rules, and very helpfully the answer was, you've got to do what's right. I didn't lose my job in that instance. I know of another friend who did resign because of the nature of what they discovered. Would we have a claim? Whether it's constructive dismissal or whether it's unfair dismissal depends on whether fired or resign. Possibly, yeah. But I would try to influence first. I know we'll probably come on to some of the red flags, but the chances of everybody, if it's that serious, the chances of everyone in the board sharing the same unethical view is slim, and there are ways to try and protect one's job engagement as well.
Talking then, because there'll be some people today listening who are maybe trainees or younger people within the in-house counsel team, that's often more difficult to work out what your role is in something like this. What happens if, for example, you find out something that you're concerned about? How, as a junior, should you be influencing?
Assuming you're not the only in-house lawyer, as trainees, as sort of people in the early stages of career, that's what the GC's job is. So our role at that stage is to ensure that we've got as much information, dispassionate information, to help our boss or our boss's boss escalate it. There's one example I remember from early in my career. It was when I was at Wetherspoon, and I can say this because it's actually got a happy ending, thankfully, where we were involved with something. And for those of the audience that know Wetherspoon, they'll be aware of Tim Martin, or Sir Tim Martin as he is now. He holds some controversial views which he airs in the media and public, but a very astute man, and as with many self-made multimillionaires, can at times be quite demanding. And some of this, whatever the project was we were working on, he asked us to do something, and my boss at the time came to me and said, I think that poses a conduct issue for you. When I looked at it, I thought, yeah, you're right. So she and I arranged a meeting with Sir Tim to go and explain it. Very unhelpfully, 2 minutes before the meeting, I got a text from her saying, I've got a clash, you'll have to do this on your own, which is a lesson in leadership there, perhaps, as well. So Tim and I met. I gave him my speech about conduct, and he went quiet. At that point, strange what goes through one's mind at that time. All I could think of is, what time is the next train home? But at the end of it felt like an eternity, but it's probably only about 10 or 15 seconds. And his response was, Jonathan, I will never ask you to do anything that infringes your professional conduct rules, and I will never authorize anyone within Wetherspoon to do so either. But what you're not aware of is, and he then went on to explain some background that I wasn't aware of, which when I heard it, I thought, yes, actually, that changes considerably. And I'd never had any reason to mistrust Tim. From that day onwards, I knew he was an honourable man as well. And it's an example that I think of to go, most businesses do want to do the right thing. He called my boss up and tore a strip offer for sending me in on my own, so it ended well for everyone. I'm not her, obviously. But that's probably an extreme example. But as a junior, our role is to make sure that our facts are straight and to escalate.
Yeah, I think that's very important about getting your facts straight. Be curious. But
Yeah.
one of the questions as well was, well, what happens if somebody's not listening to you? If you're a senior counsel or the relevant department that you're working in isn't listening, I guess if there's a GC above that, you go and escalate to them. But what else would you do in that circumstance, Jonathan?
It's without walking around trying to find problems under every stone. It's useful to have thought in advance of what and to whom should things be escalated. Depends on the size of business, of course, as well. If you're a GC, then whoever you report into, who probably won't be a lawyer, will be a first port of contact. They may be board level. You may be a board level, the GC as well, of course. When I had ascertained my escalation process, assuming we don't go to external regulators, etc., I would always ended with one of the non-exec directors. Again, depending on the business, if it's possible, and there's a non-exec director who's also a shareholder, that adds a considerable additional layer of influence. And I know of one person that did have to follow that route, and the non-exec stepped up to the mark, as much to discharge their Companies Act duties, but as well as they were a significant shareholder. And the matter was resolved before it became externally reportable and before the mischief that was concerned actually occurred.
Thank you. James, you talked about some of the tactics in the litigation. Do you think that coming out of the inquiry, or generally now, people ought to be thinking a lot more carefully about how they fight litigation? If they're fighting it too hard, trying to outspend, for example, another party, to be very oppressive, is that something that we should no longer be doing?
I think we should all have more of a focus on where the red lines are. I think that nothing has changed in that. Nothing's changed in the rules, and it is perfectly acceptable for clients to instruct their lawyers to fight cases robustly. There is no problem with that at all, provided it is done within the confines of the rules. And I'd suggest, provided it's done in situations where the strategic goals of the client are ethical strategic goals. So I think with those caveats, absolutely, it is perfectly fair and proper for disputes to be fought hard, and they always have been, and they always will be.
Thank you. Another question we've got from the audience is, the group action court case settled for around 58 million in 2019 after the successful High Court judgments that you mentioned. Why was this a good outcome for the postmasters, given that a lot of the settlement was eaten up by funding costs?
Really interesting question. So for those that have seen the ITV drama, there is a scene in which John Hollingworth, the actor who plays me, and also Patrick Green, were in a room, actually at the courtroom, getting a really, really hard time from a number of postmasters about why on earth the case had to settle in circumstances where we just had another phenomenal victory with the Horizon Issues trial. And I'd had quite a lot of conversations with Gwyn Hughes, who was the writer of the ITV drama, who did a fantastic job in writing the script for the ITV drama. But lots of discussions about what would go in that and other scenes, because what understandably wasn't really brought out was the fact that yes, the post office had done a damn good job outspending us because they had a bottomless pot of money, but perhaps more importantly, the settlement, we managed to get into the settlement very detailed. It was a very detailed settlement agreement that came as a consequence of 10 full days of mediation. But within that agreement, we managed to ensure that Post Office had an obligation to review all the criminal convictions, set up a compensation scheme for the other postmasters, not the 555, and also ensured that all of the county court judgments were set aside against the postmasters, that charging orders were taken off their houses. And this was in addition to the 58 million pounds. We knew that one of the consequences of a compensation scheme for the other postmasters would be that it would shine a light on how unfair it was that our 555 had to receive compensation net of the significant funding costs that Post Office had forced us to incur. It was just not fair. So it was a bit of a Hail Mary, in the sense that we couldn't guarantee that government would see that unfairness and set up another scheme for our 555. But we thought there was a decent chance of it. So thankfully that worked. So that broader strategic goal was achieved in the end, but it was exceptionally difficult to get there. So in the end, yes, absolutely. So all the 555 are now receiving full compensation, as are several other thousand postmasters.
Another question for you. If the Post Office in-house team could go back in time and do things differently, what would you recommend they do? Brilliant
question. That's the $1 million question. And again, we'll see what the inquiry says. And it's a benefit of hindsight, etc., etc. But I think a lot of us talking about this would like to think that we would get some very strategic external lawyers on board with the concept that, right, given the human impact that we can see we're having with prosecutions, and given that we know that it is theoretically possible for Horizon to be wrong, because we've seen it from the very beginning, there is therefore arguably a low probability but high impact problem here, i.e. even if it's a low probability that there's a prosecution based on incorrect Horizon evidence, the impact is unacceptably high, and we need to convince the board of that. And we need to convince the board that the prosecutions need to stop for all the right reasons, and that if we Post Office don't do that straight away, that is creating massive not only human risk but reputational and financial risk for the Post Office. Therefore, I'd like to think we'd have worked on the board to such an extent that we would then have been able to change the course of it. Benefit of hindsight, I wasn't in that situation, easy for me to say.
Thank you. I'm conscious we're about out of time. I've got one tip from one of the people on the webinar today. The Law Society has an in-house network, and you can join it via a solicitor's My Law Society account. So it sounds like a very good way of actually finding out a bit more information and building up a network. But Jonathan, can I leave the last points with you, I think? Last question. What tips would you give to anybody listening today as an in-house lawyer?
Well, it's interesting. Before the webinar, I sort of thought a little about this, and then a lot of the things James has said, that the lessons learned from the Post Office, I was mentally ticking them off my list. I think I mentioned it earlier, the key thing is start influencing now. Start helping colleagues do the right thing subtly. We've all got training that we've been involved in. Think back to red flags on the anti-bribery and corruption and modern slavery and things. Colleagues are now becoming much more familiar and aware of standards of behaviour. They might not think of it in terms of ethics, but we can help them here. Network we've mentioned as well. I think one of the other critical things is work hard to ditch the label of being a risk-averse lawyer. It's frequently attributed unfairly. But if we're seen as being ethical in our own conduct, but also business savvy at the same time, if we ever do have to stand up and say stop, people will take notice more. And that sort of links to the final one: be courageous. be courageous and act with integrity on the basis that most people want to do the right thing. I've always taken the view I would hate a colleague to come to me and say, I didn't want that to happen. Why didn't you tell me? And that's down to our own integrity as well. So yeah, and in terms of identifying whether there's an issue, it's often overlooked, but sometimes it's the most important. Understand your business, and gut feel is important. If something doesn't feel right, there's a good chance it isn't right. But with the caveat of get your facts straight.
Right, thank you. I love that. Be courageous. I think that's a really good phrase for all of us. And also be curious. Definitely be curious is one of my favourites. So thank you both for sharing your insight. I think that's been really helpful. I hope the audience, you've all enjoyed it too. Thank you so much for joining us, and we look forward to seeing you next time. Bye for now.